or for the appellant, Ralph Atkins, if I may reserve 2 minutes of my time for rebuttal argument, Your Honor. If Your Honor, please, Mr. Atkins' conviction for second-degree murder should be reversed on the basis that the evidence in this case was insufficient as a matter of law to support that conviction. This was a case that depended on proof of two men engaged in an altercation, one of whom was much younger and fitter and stronger, and one of whom was older, slower, and weaker. Mr. Atkins had been married for almost 30 years until his wife Deborah died in 2017, and when that happened, he essentially lost control of his life and went into a downward spiral that led to him losing his house and becoming a homeless man at the age of 66. And as he explained to the jury, by the time he ended up on the streets, he was not the man that he used to be. Age and poor health had taken their toll on him, and that made it particularly difficult for him to be a homeless person on the streets because, as he explained, being older and slower and weaker made him a prime target, made him a classic victim. There's a witness for the state, Gordon Miller, who was also a homeless person, testified himself that it's hard to stay safe when you don't have a home to go to, when you're on the streets, as it were. Danger can, as he explained, danger can come from all angles, and even people that you think you could trust, maybe not so. Mr. Miller explained to the jury that this is especially true for older members of the community because, as Mr. Miller explained it, younger folks don't have much respect for the elders. Mr. Miller gave us a description of the two men that Mr. Yorker, the decedent in this case, was considerably younger. Mr. Yorker was in his late 30s or early 40s, which I don't feels older now that I'm here, but that he was in good shape and very fit, that he was a fit man, a strong man, while Mr. Atkins was 68 at the time of the incident. There appear in the record pictures of Mr. Atkins at the time of his arrest, and we can see that Mr. Atkins was very thin. He's clearly an older gentleman. He doesn't appear to have a lot of weight on him. He doesn't appear to have a lot to him. It's clear from looking at the pictures that he's been leading a difficult life for a period of time. Mr. Atkins explained that in the period that he had been on the streets, he'd been robbed several times and beaten up several times, and explained that he had essentially lost a variety of his valuable possessions and that he had been the victim of a variety of assaults and difficulties. So that brings us to sort of the setting of this. The court may be familiar with the viaduct over here and where Interstate 40 crosses through downtown. The area underneath Interstate 40 is very close to Knoxville's rescue mission and is a place where folks who don't have a home spend their days and congregate. The city has taken some of that and established what they call a safe space, which provides some services for folks who don't have a home. There are bathroom facilities, there are some sinks and toilets, and there are benches for people to sit and spend some time there. And there is some security to an extent. We heard testimony at trial from the security officer. Mr. Atkins explained that morning he had gone to the safe space to use the restroom facilities, to brush his teeth, to shave, to take care of himself that morning. And when he got there, he saw Mr. Yorker sitting at a table with another man, and it looked like the men were using drugs. We heard that the drug use in that community is a difficult problem. And Mr. Atkins says that Mr. Yorker challenged him and I wanted to know, what are you looking at? That apparently he had looked at the men too long or looked at them in a way that Mr. Yorker took as disrespectful, which I think is proof that sort of highlights these difficulties that we have, that this is a sort of confrontation that may not have been preceded by anything that Mr. Atkins did on purpose. He may have simply just looked at the man too long, and the man challenged him. What are you looking at? What do you want? What are you doing? Mr. Atkins attempted to get Mr. Yorker to leave him alone. There's testimony that Mr. Atkins was brandishing a knife, but the man who describes that for us tells us, and this is in the record at page 32, Mr. Miller explains that Mr. Atkins had the knife out, but that he had put the knife away. And though he had the knife out, he put the knife away, and it wasn't until Mr. Yorker stood up out of the blue that Mr. Atkins got the knife out again.
Hedrick, is it my review of the briefs and the record in the case indicates two accounts.
I do agree with that. I think that there are in large part, yes.
Doesn't that give up the efficiency analysis?
So I don't know that that's necessarily true, because we still have to analyze whether this was. Mr. Atkins explained that he felt that he had no choice because of his history of having been attacked and assaulted.
In fact, on a sufficiency, I think we'd be bound to discount it. So does the testimony of the victim's friend, of the other witnesses the state submitted, they establish the elements of second degree murder?
If we take and recognizing that I'm in a difficult position on this one, because we take the evidence in the light most favorable to the state and give the state those inferences, I think that's a conclusion that can be drawn. Well, the question, of course, then becomes, under these facts, if Mr. Atkins does not act in self-defense, does he act based on adequate provocation? That is do these facts more appropriately support voluntary manslaughter, for example, because you have this dispute between these men, particularly a man with this history of being assaulted. You have the man saying, forgive me, but saying, I'll shove that knife up your ass. These are questions for the trier of fact.
So the victim's friend testified that there was provocation.
The jury was so instructed, but there are parts of the record where the victim's friend seems to indicate that there may actually have been more than he leads on to. So, for example, when we look at page 33 in the record,
under the standard of review, though, wouldn't we be required to discount that evidence? Not viewing the evidence in the light most favorable to the state.
I think that it would be difficult for the court to pick and choose to discount portions of the witness's story. I don't disagree.
The standard of review requires us to construe all the evidence in the light most favorable to the state, all reasonable to the state, discount all countervailing evidence.
And you are correct.
Yes, the inconsistency is the witness is not credible as a matter of law.
You're correct. That is a correct statement of law, and I don't disagree with that, Your Honor. What I'm intending to say is that within this story, there are certain things that are irreconcilable. For example, and I guess by way of example, when we look at this witness testimony, he says that Eric, out of the blue, just stood, and then he stops and says, Ralph had the knife out. And so there are these, for lack of a better term, cracks in the story that we're being given that seem to suggest there must have been something more than just Mr. Atkins came from the restroom, pulled a knife out, and stabbed this man. Or even, be that in a second degree or worse, but that there was some preceding event. And we have to conclude, I don't think we can, from this record, say there was no preceding event. So we have to, at some point, analyze that. That was the jury argument was that this was self-defense, or that Mr. Atkins had a reason to do what he had done. That given this history, given what he had been through, when he's faced with Mr. Yorker, though he did not at that moment display a weapon, he was posing to a threat to Mr. Atkins. Then Mr. Atkins' response was reasonable given the threat that was posed. Although I have no choice but to concede to the court that the jury did make a decision based on that argument, and this court respectfully is bound to give weight to the jury's decision, and is bound to respect that decision on appeal. The difficulty in this case, of course, is that this case is so close to that line between a voluntary and a second degree that it is not, in my view, respectfully, it is not quite as simple as saying this is a stabbing, it's a second degree. This is a knowing killing, it's a second degree. There's more in the record to consider. And I think respectfully that on this record, there are some of the things that are uncontroverted are that Mr. Atkins was an older man who was weaker and at a disadvantage, who was confronted by a younger man. It doesn't seem to, there's no indication in the record that Mr. Atkins began the confrontation, but that he was reacting to what this younger, fitter, stronger man was saying and doing. And that it's an unfortunate circumstance, but that Mr. Atkins' conduct was in some way justified by his position, and I don't want to say predicament, but his life predicament, as it were. And so for those reasons, I'd ask that the court reverse the judgment of the Knox County Criminal Court. Thank you all.
Good morning, Your Honors. May it please the court. My name is Garrett Ward. I'm here this morning on behalf of the state of Tennessee. Your Honors, this court must affirm the defendant's conviction for second-degree murder because it is supported by sufficient evidence. To really boil this case down to the core issue, there are two sort of operative witnesses here, both of whom offer testimony about some facts that I think opposing counsel and myself largely agree on, that there was some sort of verbal altercation between the defendant and Mr. Yorker, and that in the course of this altercation, the defendant stabs Mr. Yorker and ultimately causing his death. The disagreement arises in how these two witnesses, one being the defendant and the other being Mr. Miller, and I'll note for the court that at a couple times in my brief I refer to him as Mr. Williams. That is just a drafting error. Sadly, I am not a perfect brief writer as of yet, but I'm trying to get there. But in terms of the testimony of these two witnesses, they're pretty different in couching how this altercation occurs and what leads up to the stabbing itself. The defendant, as opposing counsel explained to this court, does testify that he's in this safe space area, that he sees the victim, that they lock eyes, that the defendant makes a variety of threatening statements, causing the defendant to feel some level of fear, causing the defendant to pull on a knife. And then, as the defendant testifies, the victim makes another threat, seemingly threatening to stab the defendant with his own knife, at which point the defendant stabs him. That's largely the version of events testified to by the defendant. On the other hand, there's Mr. Miller, who testifies that Mr. Yorker is seated at like a bench or picnic table, that he is approached by the defendant who is standing, that without Mr. Yorker standing up, the victim or the defendant pulls out this knife. It's a sort of a large fixed blade knife. It's more than a Swiss Army knife, so it's certainly a fearsome weapon. So the defendant pulls out this knife and starts brandishing it around. Mr. Miller actually takes it upon himself to try to de-escalate this situation, goes and talks to the defendant. Momentarily, it seems from his testimony, from Mr. Miller's testimony, the defendant does calm down. But then Mr. Miller testifies that it's almost as if the defendant, what Mr. Miller says is, remembers what he was doing. And the defendant then pulls out his knife and advances on Mr. Yorker. And according to Mr. Miller, that's when Mr. Yorker stands up. Again, this is, regardless of the size discrepancy between the two men, what Mr. Miller testifies to is the seated Mr. Yorker being advanced upon by the knife-wielding defendant and standing up before being stabbed. I want to clarify something for the court. There is, I'll say, the most minute bit of lack of clarity in Mr. Miller's testimony, at least momentarily, about when Mr. Yorker stands up. What Mr. Miller says, and defendant cites to this line in his brief, this line of testimony, and opposing counsel mentioned it during his portion of argument. Mr. Miller sort of in one line says Mr. Yorker stands up out of the blue, and then sort of immediately clarifies his testimony that, well, the defendant had his knife out and was walking at him. So really, Mr. Miller's testimony is pretty contradictory and pretty irreconcilable, Judge Greenholz, as you noted, with the testimony of the defendant. And Your Honors, when we have a case where the operative facts are testified to by two different witnesses who offer largely irreconcilable versions of events, it is the province of the jury to decide which one of these witnesses is more credible, which one of these witnesses should have weight given to their testimony, which one of these witnesses should be believed. And what the jury did in this case is accredit the testimony of Mr. Miller, discredit the testimony of the defendant, and find the defendant guilty of second-degree murder based on this weight and credibility determination. This court may not upset that determination here on appeal. Under the applicable standard of review for sufficiency of the evidence, this court must affirm the judgment of the Knox County Criminal Court. This court has no further questions. I'd ask that you affirm. Thank you, Your Honors.
Sometimes wisdom is having it but not using it. Unless there's any further questions, I don't have any further argument for the court. Thank you, Your Honors.
Thank you. Appreciate counsel helping us with this case today. All right, do we have anything else set on the morning docket? Okay. All right, we're going to be in recess then until 1:30.
All right.